My lord, I beg to mention item number 5, 9, and 11, my lord. I had submitted, my lord, an advance at mention, my lord. First one.
Request, please wait because we have to look at the record. Yes. We are looking at the record, we are finding it difficult to adjourn. We said 2019 matters. Please wait. We'll adjourn it, but please wait.
It's in the head.
Ask somebody to be here. Take note of it.
My
I will not pass advice orders.
lord, my lord.
My lord, I have a prayer in item 3, my lord. My father has expired, my lord, last week, my lord. I could not proceed in the case, my lord, today, my lord. I could not take preparation, my lord. Item 3, my lord.
2019-20 matters.
I understood, my lord.
Record.
Just after vacation, my lord, I'll take the preparation.
Sorry to hear that.
My lord.
What says that? They're made by.
Somebody will know.
Lordship, in regards to item 20, I have submitted an adjournment leave yesterday. I'm praying for an adjournment in this matter. Nothing will be taken up after the before vacation.
20.
20, Lordship.
You take the consent of the other side.
Lordship, yes, I have submitted the adjournment leave.
What says that? They're made by.
A.K. Ghosh on behalf of Mr. Take More.
AK.
A.K. Ghosh.
Take it forward on behalf of Mr. Take Forward and the government advocate, the matters may come out. Yes, Lord.
So back to item 7, Lordship. So sir, in this case, Aggressive Council is out of town, Lordship. He went to notice native village to cast his vote, Lordship.
Please wait. 2019 matters are not adjourned. And the matter is about.
So big mention Lordship, item number 4, Lordship.
Please wait. 2019 matters we are not adjourning unless we look at it.
For motion, item 2. Item 4 for motion.
I will consolidate we will do Lakhimpur also. So Lakhimpur. For Lordship.
What says that represented that they are made by the council of the petition. Matters from the job to list again. 22nd and
Master person.
Item 5.
see what.
Item five just
Same order.
mentioned, same order. Item five,
Item 6.
authorization. Six nine, no? Seven you mentioned conversation.
It none appears in call for the petition, the respondents are represented. Points of justice and questions account today, list again on.
You will prefer to go to the. Because usually क्या format?
Item 7.
Proceed in this case, the engaging counsel is out of town, Lordship. He went to his native village to cast his vote. Kindly we adjourn for the day, Lordship.
Both sides
Eight nine,
on the fair mental will transfer petition. So John today, list transfer also. List 7
11 nine,
Of blood.
two good.
Item 8.
Huh? This is a photo. Second day period.
That is in call, you have same place.
No conversion.
Item 9. Nine not sleep ticket.
9/11.
Both sides are represented on the fair made by land counsel for the petitioner. The matter stands adjourned today. List on in date.
Item 10.
None appears on call for the petitioner. All the respondents are represented. Just received the adjourned today. List will be known.
Item 11.
John today, list on.
Item 12 for motion.
You have 12. There's no representation of the Krishna, however, the response is for ends of justice, the magistrates of John today. List again on.
22nd April. Item 13.
Notice was already issued. Let it come for admission hearing, my lord.
What is the represented? Pursuant to orders passed earlier, the records of the tribunal is received, which requires examination. To start accordingly. Issue rule, returnable for without requiring any first steps to be taken. List the matter for hearing in the week commencing 25/5/2026. And interim order, that will be extended. Okay, the interim order was unlimited. Now you want a limited bail? Okay, on the prayer made by land counsel for the petitioner, the bail is extended only till the next date of listing.
Item 14 for motion.
Yes, Mr. Sheikh, look energetic today.
I submit before your lordship. It may be possible for the day.
Okay. We thought we saw you more energetic today.
Possibly I have slept better. I have slept better today
Oh,
night.
very good.
Okay.
You are assured of adjournment today. Okay.
What you may issue rule in.
Just a moment.
बाकी भी
Same, what says the representative? Pursuant to order passed again, the reports of the tribunal is received. What is intent to issue rule will turn out profit without requiring any steps to be taken. Next point, list the matter for hearing in the week commencing 25/5/26.
Apology.
Item 15 for motion.
Yes,
My lord, in this case, I would like to file an additional affidavit, my lord. Direct linkage certificate yet to file, my lord. In this case, mother of the petitioner already declared as Indian. And that judgment is also we annex here. And
where is that order?
order, my lord, at page 33, my lord. It is admitted fact that the father of the petitioner came India from Bangladesh, and subsequently he was registered as in 1966. That registration certificate is also we annex here.
You see, you don't draw your lineage from your mother. Even if your mother is declared to be a foreign Indian, you don't draw lineage from there. Please come to page 38.
My lord,
I fail to find whether you have disclosed your name of your mother here.
here, my lord, only reference is there at page paragraph 4, the voter list of 1966. In that only
But you don't take
104,
your name. Your mother was either to hidden.
his name was not, her name was not mentioned here, my lord.
Not mentioned.
But her mother's name appeared in the voter list of 1966.
Can we adjourn it? We are not giving you permission, but we adjourn it, do whatever we want.
The registration certificate is also there at page 21.
But the pleadings, so I think. the
Not
documents,
complete.
pleading-
WS says no mention option.
What says represented on the prayer made by the counsel for the petitioner, the matter stands adjourned today. Next, review of the projection made in the writ petition, court is inclined to issue notice to turn over on 22/5/2026. Without requiring any steps to be taken. Next paragraph, list the matter in the admission column on 22/5/2026.
Obliged.
Item 16. May I please, matter may be adjourned for the day, Lordship. Because engaged counsel has gone for delay, Lordship, on account of election purpose. Okay, what says represented? On the prayer made by counsel for the petitioner, the matter stands adjourned. One second. You see? Pursuant to the order passed earlier, the records of the tribunal is received, which requires examination. Court is inclined to admit the trying to issue rule without requiring any fresh steps to be taken. Next, this is the matter for hearing in the week commencing 25/5/2026. Much obliged.
Item 17.
May I please note?
Just one. Verma,
Yes, Lordship.
you remember yesterday I was upset with the learned council.
And that Mr. Paul.
Yes,
Yes, Lordship.
there. I'll show you the record, what has happened. he was so emphatically making a statement that he has challenged the impugned order.
Review petition.
Now see what has happened.
Lordship, in this,
First, first one. Look at the prayer. Look at the prayer in the writ petition.
Pray Lordship.
Prayer.
In the review, Lordship.
It is the writ petition,
Oh,
the
the
prayer.
petition. Sure.
The learned law council doesn't even know how to make a prayer.
Maybe the typographical error, Lordship.
This is not typographical error. You see, if you are challenging the order of a review, you challenge the order of a review corresponding to so-and-so opinion.
It's challenged both.
Corresponding to, it is an order of so-and-so review order
Corresponding
corresponding
to final
to
order.
opinion. Doesn't know how to draft.
Lordship, finally, what happened? Lordship passed order.
I can't pass an order. I can't do anything. With this prayer, I can't do anything. I have to record the incapability of the lawyer and then ask him to amend the prayer. Just pass an order. Upon after hearing Mr. A. for learned counsel for the petitioner, upon hearing Mr. A. for learned counsel for the petitioner for some time, it is noticed that the prayer in the writ petition is clumsily drafted without assailing the impugned opinion dated so and so. Full stop. The rather, instead of assailing the impugned opinion dated so and so, the prayer is to the effect of challenging the order dated so and so passed in the review petition, erroneously stated to be corresponding to the
Final order.
opinion dated so and so. Next paragraph. Thus, the impugned opinion having not been assailed, for ends of justice, the court is compelled to adjourn the matter. The learned counsel for the petitioner is put to notice about his incompetence in drafting the prayer. So that he will take adequate care while making a prayer in the writ petition. Next paragraph. Under the circumstances, the court grants liberty to the petitioner to amend the prayer in the petition. Next paragraph. Expressing please don't give a date after. This is yesterday's order. Huh? This is yesterday's order in chamber.
Yes, sir.
Yesterday he argued against himself. He gave a citation which goes against him.
The Supreme Court.
You are very decided, never saw the high court records.
58, 59 sale deeds were there, Lordship.
Never saw anything. Yes, item 17.
Lordship, the clause title has to be rectified, Lordship.
Hmm.
Respondent 6 has to be corrected
6.
for District Commissioner. Sorry, Madam, Deputy Commissioner.
But now you'll have to file an application, IA and all, everything, and then again come.
I am fine.
Also, is represented, Ms. A. Verma, and it's standing for the border and FT matters has admitted that a non-existing authority has been included as respondent number 6. Probably on the prayer made by one counsel for the petition, the matters is everyone to enable her to file interlocutory application for amending the cost item in respect of respondent number 6. List as and when the interlocutory application is filed.
Yes, ma'am. I'll look.
Item 18 or motion.
May I please, Lordship? My lord, impugned order is page 50. Your Lordship, the tribunal has declared me as foreigner of post 71. But,
What is the explanation for delay?
my lord, that Lordship may kindly see page 9. Para 14. That the humble petitioner most respectfully submits that after the passing of the impugned order dated so, she could not take immediate steps for filing writ petition as she was not informed immediately nor advised by her engaged counsel regarding remedy available before the Honorable High Court. The lawyer informed her about the impugned order only in the month of December 25. And then only she came to know about the fate of her case. Furthermore, the petitioner is a person of limited financial means and had to arrange the necessary expenses for filing the present petition by collecting funds from her relatives and well-wishers, whose caused further delay. The said delay is neither willful nor deliberate, but occurred due to the
Mr. Mahmood, acceptable. I have never found a downtrodden person not coming to the lawyer's place and getting information about their case. Very rich people will do it. They think that it's lawyer's duty to inform them. But a poor person, I have never found a poor person defaulting and appearing in the lawyer's chambers. I don't have that experience.
But Lordship, that Lordship would decide, but for a moment I invite your Lordship kindly come to page 53.
No, but
Page 53, Lordship kindly say, even I have annexed my birth certificate. My birth certificate, that is the most important document. Then, my lord, the NRC of 1951 in the name of my father, in the name of my, that's 15, page 15, that is grandfather and father, page 15. Yes, kindly see, page 15, the NRC of 1951, here Mujibur Sheikh is my father, Nek Mahmud is my grandfather. And thereafter, my lord, And the
You see,
voter list,
This explanation doesn't make sense. You know what has happened. Definitely you must have read it. You say that in 1966, since 66, your father's name did not appear in the voters list.
dated, the
Then you
date,
say that my father suffered from mental illness.
yes.
For mental illness, you're not denied suffrage.
Well, that's why they did not record in these 2 years. Later on, they have recorded my father's
Never
name.
happens.
Later on,
It never happens.
my father's name was recorded. Only in 66, 70, that is not there, but thereafter, in 85, his name is there. NRC had his name is there. In between, he was suffering from illness. So on merit, my lordship may kindly consider that matter later on. But for the time being, my lord, as I have annexed a large number of documents, including my birth certificate, NRC 51 of my father as well as grandfather, electoral roll of 66, where my grandfather's name is there, 70, where my grandfather's names are there.
Mr. Mahmood, it is a borrowed voters list. The age difference between your and the
Regarding anomalies, I
father
have
and my grandmother is only 4 years.
anomalies, I have explained in test 44, my lord. My test 44, and that is my WS. At the earliest point, I have discussed this. Test 44. Test 44, para 11, second part. I hereby declare that the opposite party's actual and correct name is Murjina Bibi.
That the difference between your fathers and the grandmother is only 4 years.
Well, that is recorded better. I cannot go here and there accepting that. But my lord, I will give proper explanation. I will satisfy your lordship. For the timing, my lord,
Age of the projected grandmother is 38 years. Projected father is 42 years.
38 and 42, that is,
Son is 42 and mother is 38.
son. Well, a matter of record, well, what I can say, my lord. They're written like that. I cannot deny, nor I have concealed this. I have openly brought everything to your notice for consideration.
No, this is not in your petition. This is only after looking at the opinion.
So, my lord, that matter, there so many, if a person has,
Mr. M, you know, then ask for the petitioner and also for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated page 50, 19/12/2020, passed by so-and-so in case number so-and-so, SP reference number so-and-so, by which the petitioner was declared to be a foreigner post 25/3/1971 stream. Next, in view of the inordinate delay in assailing the impugned opinion, keeping the issue of maintainability open, I issue notice returnable on so-and-so. Give data for returnable on so-and-so. Extra copies within 2 days, call for the records of the following email address of the learned tribunal. Next, prepared for bail shall be considered on receipt of the tribunal's records. Next, in the meantime, if the petitioner, namely so-and-so, is apprehended, he shall not be deported out of the country without order of the court. Next, the petitioner shall have production of a certified copy of the order before the Superintendent of Police, border, which place? Border Dhubri, to bring the order to the notice of the said authority. List on so-and-so. 11th.
my lord, some interim protection.
No, not to be deported.
Obliged.
Bail is not granted.
Obliged. My lord, item 1 may kindly be taken. I was in court number 9 if item 1.
Time being item 1.
Here, my lord, this is an ex parte order. Now, lordship may kindly see order sheets. Order sheets, my lord, page 28 kindly see. The last order, Lordship may kindly see, page 36, my lord. OP, page 36, order dated 9/10/18. OP is absent without any step. Case is proceeded for ex parte hearing and final order. Now, here, my lord, notice is served. Notice is not served upon me. It is not written. Again, 22/11/2018 order. OP is absent. Case is heard ex parte. OP is a foreigner who had illegally entered. So this is the finding. But here, the order says, Lordship would kindly see, page 35. For a moment, kindly come to page 35. Order dated 14/9/2017. OP is absent, notice issued, has not returned. Fixed so and so for appearance and for filing WS. Then 1/11/17, OP is absent without any step, be it
You look here,
awaited.
Mr. Mahmood, you'll never be able to tackle us without looking the LCR. You'll never be able to do it. Yesterday also we told you.
I have all orders that I have, yeah, let me see. 14/9/17.
If you hate trial court records, you'll not be able to do it. Look at the service report, yours, some impression with as well as the written there. Now you will look at the order dated page 35, 7/7/2017.
Okay.
7/7/2017. OP is present.
Yes.
Service notice returned with the report. Let it be awaited. So and so for filing of written statement.
Well, I understand that, but kindly see 8/8/17 order, what contradictory with each other?
We don't know, but.
8/8, OP is absent, notice issued to OP has not returned. Be it forfeited for appearance so. On 8/8/17, the learned tribunal says notice issued for OP has not returned. But in 7/7, the learned tribunal's OP is present. So that is there, madam. Here you see the notice was served upon her. In the Jarikarak's report, that is there. The learned tribunal's order is contradictory. In 7/7, he says notice is awaited. And awaited. 8/8, he says that notice has not returned. Notice is not returned in 14/9/17. But in Jarikaran, some different thing is there. The orders are confusing, my lord. Order says, the Jarikarak's report is clear. Worship here 14/9/17 order. Page 35. Copy is absent. Notice issued has not returned. 14. It is 14.
7/7/17.
Yes. Everything is confusing. Alhamdulillah. Orders are confusing and the conduct of the party is also confusing. Now I leave it a lordship.
He
But after
appeared
all,
only once,
my lord,
appeared only once, never filed anything, lordship.
my
And
lord,
that too after 2 years of,
no, I have seen.
from
He appeared once.
from 15. For me, yes, lordship. That's where he appeared.
That is when I
Yes.
no, this is this. It is submissive.
Seen, yes, 9, 10, 18.
9, 10, 18.
When they pass.
9, 10, 18. 9, 10, 18.
836, lordship.
Yes.
Yes, lordship. 7, 7. Present.
7, 7, 17. The Lioness Tribunal writes in
Get him to the court. First
9,
notice was
10.
issued in 15.
Tribunal says that it is seen by tribunal on 9, 10, 18. And he has filed, on that day, he comes to know the notice is served. But the proceeding has come to the tribunal on 7, 7, 70. Then why the learned tribunal has said that 9, 10, 18? So all are confusing, my lord. All are confusing. Now I leave to your lordship, my lord. On expiry order, my lord, some cost may kindly be imposed. I have every document. My lord, I have every document to prove my citizenship. So, my lord, I may be given a chance. I will pay something to the legal aid authority in exchange. That favor may kindly be provided.
So, Lagitul notice clearly. Lordship.
To allow him time, we'll show you the sequence. Just put the flag and give it to you. We are taking you again to this first flag order dated 7/7/17,
Yes, Lordship.
correct? And before you read this order, look at the service report again. This service report 8, 9, 10, 18, seen. Next page is that petition number is 2241
Yes,
dated 7/7/17,
yes.
correct? Now look at that order 7/7/17. 7/7/17 order says OP
Is
Absent.
present.
Absent.
first it is absent, then it
Then
is corrected to present.
Notice has returned
Service notice has returned,
with a report.
seen with a report. Let it be awaited,
Right.
correct? Now, if
Yes,
there is a
correct.
service report, you don't await a service report again. Fix 8/8/17 for appearance and filing of written statement. That means the petition filed on 7/7/17 was never considered then,
At that point.
correct?
Yes, Lordship.
Now you see what has happened. Perhaps on 9, 10, 18, this service report came to notice of the tribunal.
Yes.
Then perhaps he writes absent to present.
Nineteen eighteen, there's an order.
But 9, 10, 18 order
Is absent without any step.
without any steps. That means the service report was seen when?
910.
In 10.
Lordship, it may be, I'm just submitting Lordship, it may be that the first order
So
prior
then
to
what
7,
happened to that petition 2241? The tribunal will either allow it or reject it.
yes,
Order for to proceed ex parte will be passed when? When the service report comes.
yes.
Something wrong.
There is a confusion, but Lordship, first notice went out in 2015. After that, subsequent notices have been sent to him, if Lordship, please.
No. Only the order sheet says so.
Order sheet says,
Next page, turn to the next page. There's no notice again.
there is one issue fresh notice to OP, that is on 3/6/17.
After 6, 7 has come.
First notice is in 15, Lordship.
No, forget about earlier notices. We are now concerned with 7/7 notice.
7/7
After
says
this, no
notice
notice
has
was issued.
returned.
After this, no notice was issued.
Yes.
So
Maybe it is, this one is being referred to the 3/6/17 notice, because there it says OP is absent, issue fresh notice to OP.
that is gone.
So that fresh
Come.
notice must have gone on
7/7,
3/6/17.
that's why 7/7 comes.
7/7 comes for, 6/7/7 for
Appearance and the
appearance for filing of WL.
Yes, and 7/7, the petition is there, 2241.
OP is present, service notice has returned with report.
let it be
Let it
awaited.
be awaited. That last
Then what
second
should be
line,
awaited?
second line ought not to have been there, because
So,
maybe it's a routine manner.
no. The ideal order would have been that notice
OP is
returned after
present.
service,
Yes,
he files petition number 2241 for adjournment, next date it for written statement.
written statement. It is written, but that one line has spoiled it. Let it be awaited. Fix 8/8/2017
See,
for
when service report returns, every presiding officer will see,
Mark
make
it.
it seen on that day.
Yes, Lordship.
So,
The,
give an opportunity.
the continuity is not there, Lordship. No, that's fine.
Absolutely bad, like you were going to do.
You thank your stars that we know how to read the trial court record. If you don't
Otherwise-
assist us with trial court records, you're not going to spend more time there. I don't know why is this, why it is happening. Everybody thinks that trial court record is something for lower court record, lawyer to see. You don't know, it, don't appreciate that. If you don't look at the LCR, you won't be able to assist us. even for a moment, even for smallest thing, you will not be able to assist us.
I'll limit it for professional.
But this time you know, done counsel for the petitioner and so for the respondent. Next one. By filing this writ petition in Article 226 of the Constitution of India, the petitioner has said the party opinion, page 37, dated 22/11/2018, passed by so and so and so and so. By which the petitioner, namely so and so, was declared to be a foreigner of post 25 in 1971 state. Next, by the learned counsel for the petitioner, in order to ascertain the impugned ex parte opinion, has submitted that the order passed by the learned tribunal is quite confusing. Next, on a perusal of the records of the learned tribunal, it is noticed that the proceeding was registered against the petitioner on 8/10/2010, and thereafter notice, and thereafter notice was issued on the respondent, on the petitioner. Four 12/2022, 4/12/2012. It was made returnable on 29/12/2012. It is, as per the service report, the notice was served on Razia Begum, wife of the petitioner. But the petitioner failed to appear on 29/12/2012. However, instead of proceeding ex parte, the learned tribunal continued to wait for appearance of the petitioner till 24/2013, and on 24/2013, order was passed to proceed ex parte against the petitioner. However, the next date, i.e. 18/5/2013, once again the Travel issued notice.
I would propose it to another night.
So the process was returned after an endorsement dated 28/5/2016. The learned tribunal continued to pass orders awaiting service report, appearance and written statement. And thereafter, the next notice for appearance was issued only on 3/6/2017, fixing the next date of appearance on 7/7/17. And the notice were duly served on the petitioner, who has accepted the notice by putting his LTI on the written report. Billing process service report dated 20/6/2017. Next para. On 7/7/2017, the petitioner had appeared before the learned tribunal and by filing petition number 2241 dated 7/7/2017, wait for another date, submit written statement. The learned tribunal by its order dated 7/7/2017, recorded return of the notice. However, having mentioned that notice has returned with a report, the learned tribunal makes further order, noted let it be awaited. Thereafter, several orders were passed from time to time and from time to time. However, it is seen, it is noticed that the process service report dated 26/2017, fixing the date of appearance on 7/7/2017, was endorsed as seen by the learned tribunal only on 9/10/2018. So there is no order regarding petition number 2241 of dated 7/7/2017 in the order sheet. So despite Not that. Several other orders were passed from time to time, and the ex parte opinion was pronounced on 22/11/2018. Next. Supposing the claim made in this writ petition from the learned standing counsel for the FT and border matters has submitted that as the petitioner appeared before the learned tribunal on 7/7/2017 along with his learned counsel, who has filed his wakalatama, the subsequent non-appearance would would show his subsequent conduct of not appearing before the learned tribunal and to participate in the proceedings. So accordingly, Kamachi has justified the ex parte opinion. Next one. Next one. We are surprised to note that the learned member from a foreigners, the learned foreigners tribunal failed to appreciate the provisions of Order 3 within bracket 14 of the foreigners tribunal's orders and did not take care to record the presence of the petitioner on 7/7/2017 and to deal with the petition number 2241 of 7/7/2017. With the appearance of the petitioner was over, but the tribunal ought to have completed the proceedings within the time as prescribed under Order 3 within bracket 14 of the foreigners within bracket tribunal bracket order from 1964. First of all, we don't see any logic in accepting the return of service and still pass an order to await the report. Next paragraph. Although the conduct of the petitioner is not good for not appearing in the said learned tribunal after 7/7/2017, and as we've already taken steps but the orders that were passed after they passed on 8/8/2017, 14/9/2017, 1/4/2017 indicates that the learned tribunal was still awaiting return of the service report. Mustafa has mentioned earlier, service report was seen by the learned tribunal only on 9/10/2018. However, having seen the service report, yet in the order dated 9/10/2018, this learned tribunal has not recorded the service report in the order. Under the circumstances, as the learned tribunal failed to take notice of the current service report by subsequent orders dated 8/8/2017, 14/9/2017, and 1/4/2017. Notice of the constitutional opinions are. One 11/17. 1/11. It should be given one opportunity to file his written statement. Oh, no, something more has happened.
Lordship,
Something more has happened. We'll take our time. This we did not notice. Please go ahead. You know, what we now notice is that we are matching the signatures of the member. And we have seen that perhaps there was change in members.
change
The
of
earlier member was there till 7/3/2018. A new member joins and passes the first order on 15/6/2018. He goes by the earlier orders. And on third date, that is 9/10/2018, sees the service report and endorses that seal,
signature.
and thereafter passes expiry. So the second presiding officer was right. The error is of the first presiding officer. Just stop that. Huh? On the order sheet, it also appears that since the initiation of this case, there was a different presiding officer as member, learned member, till order dated 7/3/2018. And the presiding officer, being the new member, took up the matters is order dated 15/6/2018. But this is evident because of the change in the signature of the learned member. Thus, the subsequent learned member, having noticed the service report, had seen it on 9/10/2018 and proceeded to pass ex parte order. Because therefore the default was on part of the previous member dealt with the record till 7/3/2018. That is okay. As subsequent to the appearance of the petitioner, the tribunal still awaited the service report. What is of the constitutional opinion that the petitioner be granted one opportunity to contest the proceedings by filing his written statement. However, in view of the default on part of the petitioner, then here you contest the proceedings. After having appeared on 7/7/2017. Same calls for payment of cost to be deposited before the district legal services authority. Udalguri. Next, following conditional on this. Next one. The matter is remanded back to the learned member from a foreigners tribunal, Udalguri. Grant to the petitioner one opportunity to also for taking up the proceeding afresh. Next, the petitioner, who is duly represented by his learned counsel, is directed to appear before the learned member of foreigners tribunal, Udalguri, positively on 20/5/2026, and to file his written statement and produce all relevant documents in support of his defense. Along with the written statement and certified copy of the order, the petitioner shall also submit proof of deposit of cost of rupees 6,000 before the learned secretary, district legal services authority, Udalguri. And the written statement of the petitioner shall only be accepted on payment of such cost. Next, in order to facilitate the appearance of the petitioner and to file his written statement from the opinion dated 22/11/2018 is conditionally set aside by providing that in the event the petitioner fails to appear on the date fixed, this order shall stand lapsed by a flux of time. Without the effect of the aforesaid condition would be that the opinion dated 22/11/2018 would stand revived without any further order of the court. Next, the tribunal shall provide sufficient time to the petitioner to file evidence and to produce witnesses. And thereafter, the next paper, thereafter the tribunal shall dispose of the proceedings as far as practicable within the time is permitted under order 3 in bracket 14 of the foreigners within bracket tribunals, order from 1954. So 6,000 cost, next date of appearance, written statement must be filed, otherwise the opinion would divide.
My appearance on 25. That 625,
I won't remember.
because holidays are there.
Huh?
Good
But
for
it's not there. So I think it will be 22/5. Huh? What is the date?
22/5.
No, date for appearance. Huh? Yeah. 20 May.
29 of
20 May.
20th of
25. More than a month.
rupees 6,000.
6 years.
Per year 1,000 of lifespan. But it is bigger amount for them. Even then, we are satisfied. Of lifespan.
You put this one, sir.
Huh?
You put some.
Let's just send back the reports.
Supply item 26 for motion.
Net the lordship, lordship.
Mr. Sarkar,
Improved order.
there was a matter where we had to deliver orders.
Yes.
Item 25. It is wrongly listed here because it will be by a different bench. That bench will be constituted at 2 o'clock.
Today.
Yes, because this is not by this bench. It was along with Justice M. Kalita. So that bench will be reconstituted. Shall be constituted perhaps at 2. Justice M. K. Kalita. So the delivery of orders, item 25, will be perhaps at 2.
Improved order.
Contested case lordship, impugn order case 92 lordship,
Date to follow.
date 17 to 26. Date of opinion.
Heard Mr. James Suleiman, I'm counsel to the petitioner, and so for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 17/2/2026, page 92, passed by so-and-so in case number so-and-so, police reference number so-and-so, by which the petitioner was declared to be a foreigner post 25 to 1971 stream. Notice returnable in 4 weeks, extra copies within 2 days. Call for the records to the following email address. The prayer for bail is opposed by the learned standing counsel for the FT and border matters. Considering the position, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police border. Which place?
District Dubli.
Dubli. District of Police.
Supply item 27.
Obliged.
May please, Your Lordship. Impugn order is at page number 37, Your Lordship. Order dated 38/2025, Your Lordship.
Heard Mr. A. Rahman, learned counsel for the petitioner, and so for the respondents. Opinion dated
38/2025.
3/08/2025, passed by so-and-so in FT case number so-and-so, SP reference number so-and-so, by which the petitioner was declared to be a foreigner post 25 to 1971 stream. Notice returnable on, we did after 4 weeks, returnable on so-and-so. Extra copies within 2 days, call for the relevant record from the concerned tribunal to following email address. Next, the prayer for bail shall be considered on receipt of the tribunal's records. Oh, this is 8/25. Okay,
Yes, Your
make it 4 weeks. Make it 4 weeks. 10 days time to take bail of this 5,000 to the satisfaction of Superintendent of Police border, Nalwali. List after 4 weeks on receipt of the tribunal's.
Highly obliged, Your Lordship.
Item 28 for motion.
May please, Your Lordship. Impugn order is at page number 112, my lord.
112. Mr. M.I. Hussain, also for the petitioners. M.A. Hussain, and counsel for the petitioner. Proceeding of page 112 dated 30 April 2025, passed by so and so in there are three references. There are three references. Hit them 1, 2, and 3. Right. Number 1. Then give the second bracket corresponding to number 2, comma, arising out of number 3. Thereby declaring the petitioner to be a foreigner post 25 to 1970 stream. Notice returnable in 4 weeks, stock of into this, all for the records. To the following email address, the bail is opposed by the understanding of the results. And this time take bail of this file order to the satisfaction of spend of police border, Walfara. This after 4 weeks on visit of Latin's. Take a short break and come back.
For admission, item 19.
Lordship, as per the last order, we are supposed to get the instructions, Lordship. The written instructions have not yet been received, Lordship. But telephonically, we have received the instruction that no employment can be given, Lordship. No employment scheme is there, Lordship, for engaging the petitioner. There is no such scheme,
Then, you see,
Lordship.
then towards palliative care, we'll have to award compensation,
Lordship.
because if that is so. But you get that instructions even for that, there is no employment.
Lordship.
uh,
Telephonically, we have received.
No, but you see, we'll have to record it. It may create unsavory experience for you. Please have it recorded so that we can close the matter by,
No, we are still awaiting the written instructions, Lordship.
wait, because then we'll have to, we have no alternative but to pass a palliative compensation.
Lordship, can it be taken up after the vacation so that in the meantime written instructions are also received?
We'll do, Mr. Kalita.
Yes, ma'am.
Lordship.
Now we are more worried about Mr. Kalita.
Lordship.
He is being pro bono appearing, he is assisting us in getting justice to this petitioner. You have the repetition with you.
Lordship.
You see, the repetition when it was filed, the petitioner was 60 years of age. That is in 2018. Now we're in 26, she will be
Six Lordship,
68 now. So we don't want to delay the matter more.
Lordship.
Correct.
Lordship, I understand.
But Mr. K. Kalita, and counsel for the petitioner. Also having his.
And
MPV
Devi
and Government advocate, as well as Mrs. S. Sharma, the standing for the Health Department. Next paragraph. The government advocate has submitted that although that she is awaiting written instructions in the matter. Mr. Bhalo, comma. The instruction matter next paragraph. We taking note of the age of the petitioner, which was 60 years as on December 2018. We request the government advocate to expedite the receipt of instructions at their end. Failing which the matter would be proceeded on the basis of materials available on record. Next paragraph, list on. Well,
after the vacation, Lordship, any day.
20.
Last week of April, Lordship,
24th April.
24th.
Oh, 23rd, 24th, there is some difficulty. 23rd.
Of last
Of
week.
last month.
Item 21 for admission.
May I please, Lordship? My lord, the petitioner is compelled to approach this honorable court for the second time, my lord. My lord, an ex parte order was passed initially, my lord, by the learned Foreigners Tribunal, Borpeta. And that ex parte order was challenged before this honorable High Court. And this honorable High Court was pleased to set aside the ex parte order, my lord. So far the, my lord, name is concerned, only the name is difficulty, my lord. Petitioner's name is Ashakali, and a notice was sent in the name of Oshukali. And on this ground, my lord, the earlier ex parte order was set aside by this honorable court. Remanding back and with the direction, my lord, that if any materials found against Ashakali, then fresh proceedings may be started against him. But the learned tribunal, my lord, pursuant to High Court's order, my lord, SP has given an application before the Foreigners Tribunal, Borpeta, that some materials has been found against Ashakali, so sanction may be granted to proceed against him. And accordingly, an inquiry committee was formed by the learned SP and made an inquiry whether Ashakali is Oshokali or not. Accordingly, my lord, it is found on the inquiry that Ashakali and Oshokali is the same person, because Ashakali also known as Oshokali, because some peoples of that locality called him Oshokali. This is the report, my lord, annexer P10, page 41. And on the basis of that, my lord, the learned tribunal and made an inquiry, and thereafter a proceeding inquiry evidence was taken from the state side, and thereafter passed the impugned order, my lord. Impugned order is page, my lord, 46, my lord. Page 46. And the relevant portion, my lord, can you see, my lord, the relevant portion is page 57. Last paragraph. And learned tribunal held that since the Oshokali and Ashakali is the same person, so ex parte order passed by this honorable court has been set aside and restore the earlier ex parte order, my lord. So hence this petition, my lord. My lord, kindly see the findings of the learned tribunal, page 57, my lord. Last paragraph. That in terms of the above foregoing discussions and after going through the end earlier order, my lord, of this honorable High Court, page 34. Relevant portion starts from page 35.
Yes, Lordship. Yes, Lordship. Lordship, let Mr. Pine address this.
Fifty-two, my lord. Yes, yes. Yes, yes. Yes. This is inquiry. Yes, madam. This is by inquiry officer. Yes, yes. Yes, ma'am. Yes, ma'am.
He was called for as the state witness, my lords. No scope is given to file WS evidence, etc., my lord. Directly, my lord, call him.
Vale. But, let me go through. My lord, can it be fixed some other day? I may go through this on opinion, just because, my lord, probably earlier there was in direction of this honorable court to remand the matter, my lord. My lord,
Yes. Ready. The remanded, the given liberty, my lord, page 34, 35, 36. Last portion 36, my lord, operative portion. Set aside.
yes. Order is
That is-
set aside.
Set aside.
Yes, ma'am. That is probably, my lord, what issue was there, my lord? Probably for this reason only, page 36, my lord. The judgment order of this noble para 3, my lord. From the above clearly it appears that proceeding before the foreigners tribunal numbers of Borpeta proceeded on the assumption that the proceeding has failed to respond to the notice, but when he was examined, said notice, the said notice was issued in the name of Osukali, not in the name of Asa. That was dispute raised by the tribunal by the petitioner before the honorable court. Had the notice been issued in the name of Asad Ali, perhaps the petitioner could not have been taken stand to being before this court now. Well, so, yes. No matter that should be given, madam. That is Yes. Yes, everything is against him only. That should be, opportunity should be given, definitely that should be given, madam. Yes.
On the prayer made by Mr. J. Pang, standing also for the FT and water matters. So this is a non-debate. Enabling to post the records and respond. The court proceedings. Next, please stop. 23. 24. 24. You want to go through this record?
Yes, no, let me go through the record. No, I have understood now, my lord, what happened here is probably because this honorable court has directed that he may not be the same person. We are certain only, my lord, that proceeding was initiated. Because this was dropped, the order opinion was set aside. Then the tribunal, my lord, proceeded that again new, my lord, whether new materials have found, they found that no, this is the same person. They proceeded the proceeding. Now, yes, my lord, they proceeded the proceeding and confirmed that this is the same person. Now, the another proceeding, next step should have been, this would be given, my lord, the notice to contract him, to approve his case. That should have been done. That has not been done. Here it is only up to the level, yes, he is the same person. Proceeding can be drawn against him. That was the finding given here. So next part should have been given, next opportunity to the petitioner to contest. That should have been given. Yes.
But Mr. Day,
My lord.
that finding will be sustained,
Yes.
that he is the same person.
Yes.
That observation is not.
My lord, my lord.
Now it is his duty to prove that he is an Indian. Yes.
Then you say. Third, easy date on. By filing this petition under Article 226 of the Constitution of India, the petitioner has claimed the opinion dated page 46, dated 4/9/2025. Passed by so and so in case number so and so corresponding to our case number so and so by the state Indian the learned tribunal
Number 7.
and restored the proceedings of FT 354 of 2019 to file pursuant to the order dated 12/2/2021 passed in WTC 608 of 2021. Having recorded the evidence of 4 PWs, including the petitioner, as witnesses for the state, the previous ex parte opinion dated 12/2/2020 passed in the said proceedings was restored. Ordering it to become operative against the petitioner, namely Ashok ASHOK, Ashok Ali, alias Ashok ASHAK, Ashok Ali. Next. Suffice to mention that the present proceedings against the petitioner was instituted in his name of Ashok Ali, ASHOK, Ashok Ali. Pushpa. The This is the previous opinion. Till what it- Ashok Ali,
The ex parte order,
the petitioner
12/2/2020.
appeared pursuant to though the notice was served by affixing on the wall of the last known address of the petitioner, which was identified by the Gauhati. And as the petitioner remained absent without steps, ex parte opinion was passed on 12/2/2020. Holding the petitioner free of order of post effect in 1971 speed. Next paragraph, agreed by the said impugn opinion. The petition filed a writ petition, which was registered and numbered as WTC 608 of 2021. Now, this court having noticed that the name of the they said, should notice was served. What did I say? Last night? In the said writ petition, it was projected that the notice in the said proceeding was issued in the name of Ashok Ali, ASHOK, Ashok Ali. But the Gauhati had stated that there was no one called Ashok Ali in the village. And the petitioner projected that his name is not Ashok Ali, ASHOK Ali, but Ashak, ASHAK, Ashak Ali. This court had set aside the ex parte opinion by order dated 12/2/2021. Passed in WBC 608 of 2021.
But the issue,
This topic was made clear that nothing prevented the state government to proceed against the petitioner, Ashak Ali, if there are materials against him. Next paragraph. The records reveal that when the case records were put up before the said learned tribunal, the said learned tribunal ordered dated 3/3/2025. Consider the memo. Letter right memo dated 3/3/2025, issued by the Superintendent of Police within bracket quarter bracket was profit to proceed against Ashak Ali, Ashak Ali. Then accordingly, the said learned tribunal by order dated 20/2/2025 now the Superintendent of Police is order profit to it against Ashak Ali. Next paragraph. Subsequent order.
my lord, one thing your lordship make clear, because it may lead otherwise also. Because in case of my lord, opinion in the name of Ashok Ali is not interfered. Opinion in the name of Ashok Ali is not interfered by this honorable court. It is said if it is, my lord, against Ashok Ali, it will not affect. Now, my lord, it is come to know that my lord, Ashok Ali and Ashok Ali is same person.
So that is okay.
Now, in that case, my lord, the Ashok Ali opinion in the name of Ashok Ali is remain. But this honorable court says opinion in case of Ashok Ali will not, this opinion will not affect the,
Everything is okay.
my lord.
What the tribunal did was very good.
Yes.
We appreciate that what was done, but it should have been extended to allow him to file written statement because,
Yes, my lord.
because you see, when you institute a proceeding against, let us say A and A1,
Yes, my lord.
you earlier proceeding was against A. Now it is against A1. Now, although your finding is saying that A and A1 is same person, but this written statement has to be given.
Yes.
If one time if that be given opportunity, it would have ended the matter.
No, no, that's why, my lord. Probably the tribunal was committed wrong, was confused because of the order of dishonorable court. My lord, dishonorable has
So
court.
that's why we are saving that
Yes,
order.
my lord.
We are
Yes,
saving that order. That's
Yes.
why we said we are saving that order.
yes. This, otherwise, my lord, if the entire opinion is not set aside, then tribunal cannot go beyond, my lord, tribunal cannot, take, my lord, fresh step.
But you see, then the state should have filed an application here for recalling of that order.
No, earlier order. No, earlier order, my lord, my understanding will be otherwise in case of Ashok Ali, my lord, earlier opinion remains.
Actually remains.
Yes, earlier opinion remains. There is an expert order. Now, if Ashok Ali and Ashok Ali is the same person, then it will remain as it is. Earlier opinion will remain as it is. Only question was whether Ashok Ali.
The procedure was wrong.
Yes.
You call the respondent in that proceeding as state witness.
No, that is my lord, only for ascertaining whether it is same or not.
That's why we are saying.
Yes.
That's why we are saying, but you.
No, what my submission is, my lord, then your lordship may set aside the earlier opinion, entire opinion.
Touching that.
No, earlier opinion of the tribunal, my lord. If it is not quashed, then it will be not possible for the proceeding.
No, because he says in his evidence, he says that in house number 205, there are two persons. I am the same person, but I cannot vote on in the name of Ashok Ali. That's what he says.
Yes.
So therefore, there are two voters in that house. Against one, there is already an opinion. Now it is Ashok Ali. So against that, the proceeding must conclude. Therefore, that opinion cannot be set aside. We
Then
don't know
Ashok
whether
Ali will
this
remain, my lord. That opinion in case of Ashok Ali will remain.
will remain.
Yes.
That's why we are saving that inquiry.
Yes.
Right, subsequent order dated 28/3/2025. Comma, the learned tribunal took note of the report of the inquiry officer. It was done pursuant to order dated 12/2/2021 passed in WPC 608 of 2021. And it was revealed in this inquiry that Ashok Ali, ASHOK, Ashok Ali, son of Rahmat, and ASHK, Ashok Ali, son of Rahmat, are same and one person. Accordingly, it appears that the government assistant government leader, learned government assistant government leader, representing the state, moved petition number 231 dated 28/3/2025, praying for summons of the witnesses as per the inquiry report dated 24/3/2025. To stop the prayer was allowed. It appears from the impugn opinion that in terms of the orders passed earlier, the tribunal had issued summons to the witnesses and on summons being issued from the state examined Dilip Ramchari EILIP-RAM-CHIAR1, the inquiry officer has PW1 was examined and cross-examined by HR. The state also examined Fiducian, FEPDUSH, Fiducially, the Congra as PW2. He was also examined, cross-examined. He was examined and his cross-examination was declined. And discharged. Next, the state examined fiducially, Congra as PW2. His examination was recorded and his cross-examination was declined. Thereafter, the state examined one Kasimuddin, KASIMUDDIN, a witness as PW3. He was also examined, but his cross-examination was declined. Thereafter, the state examined the petitioner Ashok Ali as PW4. In form of cross-examination by the state. It appears from the cross-examination of the petitioner as PW4 that he had admitted that he was that Ashok Ali and Ashak Ali is his name, and both the names were enlisted in the same house number 205 by changing from Ashok Ali to Ashak Ali so that he could cast his vote in the name of Ashok Ali. He could cast his vote as he could not cast vote in the name of Ashok Ali, as the said name was marked as D voter. Accordingly, the learned tribunal, having after appreciating the evidence of the four PWs, arrived at the conclusion that the petitioner and his learned counsel had misled this court and formed an opinion that the opinion passed on 12/2020 was still operative against Ashok Ali. And therefore, the said opinion was made operative as after recording of finding that Ashok Ali and Ashok Ali are same.
My lord. My lord, if the subsequent enquiry comes that Ashok Ali and Ashok Ali is the same person, my lord, then my lord, the earlier order may also be satisfied. Otherwise, so for the Ashok Ali is concerned, yes, Ashok Ali is concerned, that is satisfied. Ashok Ali is not satisfied because Ashok Ali is even. But my lord, now the problem is, my lord, when enquiry held, enquiry, my lord, the problem may be solved as per direction of the earlier High Court's order, my lord, that notice is to be given to the Ashok Ali. And Ashok Ali given a liberty to contest the same. My lord, initially LBO report, my lord, I understood, my lord, kindly see LBO report. There is Ashok Ali. Reference was Ashok Ali initially. Yes. No, my lord. LBO report, ERO report, Ashok Ali, SP, then change the name. My lord. My lord. That statement is there, but my lord, the fact is that some people, in the report also it is mentioned that some people called him Ashok Ali. But he himself, my lord, in the report, my lord,
It's a complete fraud.
so my lord, my humble submission of opportunity is to be given to him. That is, if that order is survived, my lord, Ashok Ali, regarding Ashok Ali,
Ashok Ali and Ashok Ali is the same person.
Ashok Ali, then Ashok Ali, what happened to Ashok Ali? Yes. After all, my lord, enquiry was done. Enquiry was done, and after enquiry, it came to light, my lord. The same person. And on the basis of this enquiry report, my lord, if the same person, if the person is same, so what is not it is reasonable to give a notice? Or earlier case may also proceed. Now they are, my lord, this order, impugned order, my lord. Impugned order I have challenged. Impugned order, my lord, it held all the facts and come to, my lord, conclusion that same person, Ashok and Ashakal is same. So if it is same, my lord, and notice is not given to him, my lord.
Suppose that person, it is the same person. Suppose that person was convicted earlier, and he said, I am not that person. Later, before this honorable court, so I may not be convicted, I may not be sent to prison. Now, that matter is sent back. In the court, it is proved that he is the same person. Now, but can the conviction be set aside? The conviction remains. Only.
No, who has committed the mistake? I have not committed the mistake.
No, it is yes, the conviction remains unless the conviction is set aside.
If the notice was issued in the proper name, my lord, kindly say, my lord, report in the 29, page 29. Ashok Ali and Ashok Ali, at that time, my lord, the notice is given to Ashok Ali. And Gaubura also says that there is none in the name of Ashok Ali.
It is not your case that the notice was served on an incorrect person. Notice came in the name of Ashok, you accepted it.
No, my lord, it is served pasting by pasting.
That's an acceptance.
Petitioner has not received any notice, my lord. It is pasting.
D5 is complied with. So that is Ashok. And you admit that in the house 205, there are two Ashok. One is Ashok, one is Ashak. That means there are existence of two voters list.
My lord, if the notice is served to the person concerned, my lord, then the my lord matter may be different. It is served on the alternative methods. Pasting, notice served on the pasting of the walls of the house.
He has to sell.
Petitioner has not signed the notice.
Original page.
It is not personally served.
I'm not.
That is
So it will deliberate and find out.
Yes.
the page 29, my lord.
This dictation done so far will remain. You can transcribe it, huh? But I'm reserving the order. Page number?
29, my lord. Ashok Ali, Pita Rahmat Ali Namor Manu, Tatagaut Nai. This is the statement of Gaubra, Fadjus Ali. He said here, and then the notice was pasting on the wall of the house.
My lord, otherwise, my lord, can it be fixed on some other day? I may also file it because there is some issues, my lord. I may file a reply to this also. Because if your lordship dispose of a remand bail, it will be, my lord, proceed again without, my lord, setting aside the earlier opinion of this honorable of the tribunal. Then it will be res judicata as well, because he admitted he is the same person. Those issues are there, my lord.
It is also questionable, my lord, whether the procedure adopted by the
Yes, ma'am.
File at least 2 days prior to the next date of listing. As per this term, 18/5/2026.
But next item 22, my lord, may be taken up 22, my lord.
We'll come at 2 o'clock, otherwise we'll be late.
Yes.
There's a meeting right now.
Yes,
At
sir.
1:50.
For delivery of orders, WPC 6172/2019, Ananta Kumar Roy versus Union of India.
the challenge fails and the repetition is dismissed. The order of bail passed on 1/10/2020 stands vacated.
Item 22 for admission.
Well, in this case, my lord, I need some time, my lord, because my lord, my name has not shown in the court list and copy had been served today itself, my lord. Copy of memo of appeal. So, my lord, let it be on 22, my lord, April.
We have a lot of cases. Either 21st or it goes to.
21st, my lord, 21st.
From the first week, we also have to omit the part of it.
No, 21st to say, 21st.
If possible, could it be a later week, 26, 27 or 28? First week is that. Okay, 27th.
My name may be shown, my lord, is just.
What says a representative on the joint claim made by learned counsel for the appellant and the responding, the matter stands adjourned today. Next, the registry shall reflect the
Appellant.
name of Mr. H. Das as learned counsel for the appellant while listing the matter next. Next paragraph, list as agreed to by both sides, list on 27/4/2026.
Lovely.
Item 23 for orders.
What this is your lordship? Lordship, this IA has been filed for rectification of the petitioner's father's name, lordship. Inadvertently, it has been typed as late, whereas he is alive.
He is alive
Yes, lordship.
and you have wrongly written as late.
Yes, lordship. Inadvertently typing error.
Then you have to again apply for rectification of the this
Right.
interrogatory application. You have a copy of the application?
Right now,
No, you show it to her. In the cost settle again, you have said late. Page 3. You have the copy? No. Give this way. I. I again you have said late.
yes.
Yes.
You have to withdraw it and file a fresh format.
Yes, lordship. With regard to your lordship.
Otherwise, you'll have to file an application for rectification and then only it can be done. So withdraw it, we give you liberty.
Yes, lordship.
On the ground that the inadvertent typing error has crept in the cost title of this interrogatory application, comma, Miss
Sorgiari, lordship. Sorgiari.
Miss U.
Sorgiari.
Sorgiari, learned counsel for the applicant. Case for leave to withdraw this interrogatory application and to approach again. To stop. All the respondents are represented. If a query is allowed, the application is dismissed from withdrawal with liberty to approach again.
Obliged, lordship.
Item 24 for orders.
May I please, your lordship? Yes. Lordship, here, lordship.
Inadvertently, Lordship, there were some mistakes in our part, Lordship. At the time of filing this leave petition, we have added respondent number 5 and 7, that is the Superintendent of Police Jorhat and District Commissioner Jorhat as respondent number 5 and 7. Here, Lordship, the petitioner was declared as foreigner by the Foreigners Tribunal Jorhat, but the reference was from the Superintendent of Police Shivsagar. My prayer is, Lordship, the name of the respondent number 5 and 7 may be struck off and Superintendent of Police Border, Shivsagar, may be added as respondent.
Your cost title is defective. Number one, you have not given the cost title separately for that WPC and this IA. Look at your application, page 1, you don't give that first cost title is for which? WPC or IA?
WPC, my lord.
So we don't know, it's not here. Now come to the second cost title at page 4. Again here, whether it is IA or it is the petition, we don't know. Now come to page number 6.
My lord.
Now you have again made here District Commissioner Shivsagar.
Yes, Lordship. Shivsagar, I want to implead him as party respondent.
You want to implead him?
Yes. Alternatively, may I say that
Shivsagar and this South Salman Mankasar Superintendent of Police.
he is from South Salman. Alternatively, may I say that the Lordship
Just
may
a moment, let us understand. You want to substitute 7,
5 and 7, my lord.
5 and 7.
Yes, Lordship.
Mr. Payne, we omit that,
Yes, yes.
allow this application.
Yes, please, sir. For better person.
Because you see, Mr. Ahmed, this is something we would not have done it. The reason is, in an interlocutory application, only those can be made parties who are already parties in the writ petition. Non-party cannot be made respondent in an interlocutory application. Ideally, you should say in the writ petition, in this IA, that so and so are prospective respondents. And then you have it implemented. Because now you have already substituted the persons in the cost title. That is something we would not have done. Third, which I am Ahmed, will counsel for the applicant. And so for the respondents. Next para. It is projected that there is an inadvertent error in hearing of respondent number 5 and 7 in the connected WBC 1623 of 2026. And accordingly, we are filing this interlocutory application, the correct authorities are sought to be substituted in place of the respondent number 5 and 7 in the connected writ petition. To stop. Next, for the having heard the runners negotiate for the FT and border matters, the player made in this interlocutory application stands allowed. Permitting substitution of respondent number 5 and 7 as under. Let's make the chart. 5 and 7. Now, new parties will be the old parties, 5 and 7 are at page 3. And new parties are at page 6 and 7. 5 and 7. This application stands allowed and disposed of. In the connected petition, you say all sides are represented in view of order passed today in IA Civil 1079 of 2026, by which substitution of respondent numbers 7, 5 and 7 are allowed, is allowed. The learned counsel for the petitioner shall submit amended cost title to the AOJ active section for being incorporated in the writ petition and for consequential amendment to the CIS data. Thereafter, the matter was listed in court.
There was a direction, Lordship, to the petitioner to appear him within a period of 10 days, Lordship.
10 days,
10 days, Lordship.
2 working days we have said. We have said 2 working days.
Lordship, earlier there was a direction to the petitioner to appear him before the superintendent of police Jorhat.
No, but
within a
for
period-
that you have to get it, the amendment has to come down.
I will file another,
Otherwise, your
Yes,
order
sir.
should not be effective because your parties will still be the
Yes.
other superintendent.
I will file another. I have to file another IA. Let the cost title be corrected
For-
first.
For extension of time.
Yes, correct.
Because Mr. Ahmed, we are not doing so for a reason. You see, we will pass the orders on good faith that you will do it. But if supposing you don't do it and you go for extension of time, then the other party will be there. They will not accept it. That's the problem.
Yes.
Supplementary item 29 for hearing.
If I may, for adjournment, your lord, my CA is equal port number 1, your lord.
Can we place my IA? Then you have to know another way but to take up that IA. How much time? How much time would be required?
Take some time to what I mentioned. On 21st floor, sir. On 21st floor.
No, but then we'll have to vacate it. You see, he is continuously pressing for the IA.
Lord.
We can't have it adjourned.
I'll just place the order in the notification.
Let him find out.
Yes.
The senior
Sure,
in court, let him find out. You can go and come back. You can go and come back.
Good. I'll inform you. I'll inform lordship will come.
No, there, one judgment was being delivered, so.
Okay.
My lord, if it is not inconvenient, I have informed Diganta Das, my lord. Can be taken
Now
up.
he is pressing for that interrogative application for vacating.
Okay. No, my lord, this morning I had a discussion with the senior, my lord, he said, okay.
I don't know. It's for you to.
But if that is the case.
This morning I had a discussion.
No, no. We are not believing you. But since he is a young counsel and pressing for that IA, perhaps between you two, he will also get a precedent. Because we have to encourage young people.
Certainly.
Nothing against you, but
No,
this is how the bar was.
end of the day, it's a brief, my lord. For him is important, and for us, my brief is important.
Okay, yes.
But if I take instructions from Mr. Das,
Please.
I'll just take instructions.
Mr. Chaudhary, you can take some rest.
No.
And by the way, this is the last matter in board.
Wish you all a very happy Bihu.
Thank you, my lord. And we also wish you a happy Bihu. The other day, 26 started. Now we are almost end of April.
Time flies.
Time flies. In a sense, it is good that we are busy. We are not able to find, I mean, even count the day. Otherwise, my lord, it's very difficult to, I mean, manage time.
It's,
Yes, no, it's all right. Yes. Good. Right.